Perfect. Thanks, Bruno. On to another question. So we've had just a simple question asking that you deal a little bit with Section 14 of the Consumer Protection Act and when a notice in terms of Section 14 should be sent.
So with lease agreements, one has to ask whether the Consumer Protection Act plays a part and governs the lease agreement. In order to determine this, we look at Section 14 of the Consumer Protection Act and we ask the question, is it a fixed-term lease agreement? Now, we all know, unfortunately, that there is no definition as to what is fixed term. So is fixed term a couple of days, a couple of weeks, a couple of months? We don't know. What we can comment on, and this comes more from experience in this industry, is that if a fixed term agreement is under 1 month, usually it's not treated as fixed term. It's treated as short term. And you can look at examples like this in the VAT Act that treats accommodation up to 28 days as commercial accommodation as opposed to your usual residential accommodation, correct? So in this instance, if we look at the CPA and we ask ourselves, would it apply to a lease agreement that's 3 weeks? Arguably, it wouldn't. If the lease agreement is 3 months, 6 months, 1 year, you will find that the CPA would normally apply. Now, this does not mean that it always will. And we've got other videos on the channel that speak about the very specific instances where in long-term lease agreements, the CPA would not apply. But usually it does. Why? Because you as a property owner are carrying on a business, and because you're carrying on a business, you're deemed to be a supplier in terms of the Consumer Protection Act. So now, basically the answer everyone wants, if the Consumer Protection Act doesn't apply, what does that mean for me as a landlord? Well, it means that you don't have, amongst many things, you don't have to abide by the 20 business day notice period, which all landlords would need to abide by in order to cancel a long-term lease agreement. What this means, let's say you have a 12-month lease agreement, the tenant breaches the lease agreement, landlord must give the tenant 20 business days to remedy their breach before the landlord is permitted to cancel the lease agreement. However, if the lease agreement is on a month-to-month basis, our opinion is that you don't have to give 20 business days notice in the event of a cancellation. You can give 7 days notice as an example, which is the usual period that you find in the industry in order to cancel the lease before you can cancel the lease agreement. So keep this in mind. And one last point, please don't confuse notice periods based on breach with notice periods based on just your usual termination. So if you're in a month-to-month lease agreement and you decide that you want to terminate, forget breach. Maybe the tenant has paid, but it's month-to-month and you want to terminate. The details in the name. It's a month-to-month. So in that case, yes, you would have to give 1 month notice in order to terminate that lease, but you would not have to prove that the tenant was in any way in breach of the agreement.
Perfect. Thanks, Bruno.
Awesome.